Okay, everyone. So sorry. Oh my God, this is crazy. We're having a little technical difficulties, but they're not insurmountable. Suzanne and I are here. We've moved rooms and want to cover off an important issue today, and it relates to questions of severance of joint tenancies. Joint tenancies, of course, are a classic planning tool that all of us use in estate planning. So we thought we'd do a little bit of an academic dive into it and talk a little bit about some of the cases to give us some more foundation on joint tenancies and where they go. So Susanna, let's start at the beginning.
Sure, yeah. Well, we certainly know that the joint tenancies, when we're talking about the concept itself, it is dependent on the four unities. The unities of interest, of possession, of title, and time. And when we talk about these kinds of interests, and we're talking about the definitions of these things, we oftentimes will go back to the decision of Zeligs versus Jane, which is a 2016 BC Court of Appeal decision that actually defined the unities for us. And so when we talk about unity of title, what that means is that the title of each joint tenant arose from the same act or the same instrument.
And then we've got unity of interest, which from the case they talk about means the holdings that are perfectly equal in nature. And that's such an important part of estate planning because they're equal in nature to the extent and the duration. So we often will hear about how much is a joint tenancy worth, and the unity of interest speaks to that.
And the unity of time really just means that all of the interests are going to vest simultaneously. So if you have two joint tenants, then both of their interests will vest at the exact same time. If you have 5 joint tenants, theirs will also vest at the same time.
So the last point of the 4 unities, which ties us together perfectly, is the unity of possession, which means each joint tenant has the right to present possession and enjoyment of the whole property. No right of exclusive possession of any individual part of the whole. So if we work with that sort of foundation and that starting point, Susanna, what do we want to consider next?
Well, assuming that all of those 4 unities are present, and I know certainly in preparing for this podcast, I stumbled upon the unities and don't remember them from law school, but having just sort of refreshed my memory here, it was very helpful. But presuming all those are present, then the question really becomes, when we're looking at a joint tenancy situation, is whether or not at the end of the day, when the surviving tenant is still alive, whether the interest to that individual is going to pass by right or survivorship, or whether they're somehow going to hold the interest on a resulting trust for the benefit of the estate.
Which brings us to the great decision of Picori and some of the other considerations. What is the intention of the grantor at the time of creation? And as Jordy likes to say, there's limited ways we can give property away. It's outright, or it's either outright or it's with strings attached. Well, in this case, we've got to look to the intention of the grantor at the time of creation. So that intention drives the question of certainty. So what are some of the uncertainties that arrive from joint tenancies, Susanna?
Well, it really is sort of determining what that intention is at the end of the day. And when we talk about intention, you say it's at that moment in time when the joint tenancy is created. We know also from just the cases that sometimes it goes beyond just that moment in time.
Yeah, we just got so much. Everyone's got to please mute. Let's carry on with the uncertainties. All right, so again, we've spoken to the Supreme Court of Canada decision. Again, I think we just got someone who's on mute, unless I don't think it's a problem on our end. So maybe Michaela can mute others or someone with more technology than we do. All right, so how is a joint tenancy severed? And that's, of course, a big question when we're dealing with estate matters and so on. So let's just talk about how joint tenancies are severed, Susanna.
Well, there's really 3 ways that a joint tenancy can be severed. The easiest one, of course, is when one of the tenants themselves unilaterally acts and severs their interest in the property, either by selling it or encumbering it or somehow otherwise dealing with it. A second way is when both parties mutually agree to sever the property, the tenancy, in which case both will have an interest as tenants in common. And then thirdly, and perhaps the most interesting one, is when there is a course of dealing that demonstrates that the parties mutually wanted to treat the joint tenancy as coming to an end, and they want to turn it into a tenancy in common. So some kind of a course of conduct or a course of dealing, the cases describe it as, to indicate a mutual intention to sever the tenancy.
So we're going to talk about the course of dealings question in a minute, because that's one that's got some more interesting elements to it. But from an estate planning standpoint, of course, and many of our family law colleagues will do this, is that when you get a client come into the room and see you and they're in a situation where there's marriage breakdown, we'll often tell the client right in that meeting. The family law bars often refresh the idea of joint tenancy, and will say, sever the joint tenancy now because you can do it unilaterally. So the unilateral severance of the joint tenancy is important in that contentious moment, but it's also important when we take our instructions, because often our clients misunderstand what joint tenancy and tenancy in common is. So it's always worth, when I'm taking my will instructions, to ask for permission to do a sub-search. And if the permission isn't granted, I put it in my report and I say, listen, I wanted to check this just because I wanted to make sure your understanding was correct. But more importantly, of course, is that what if the other joint tenant has unilaterally severed the joint tenancy without notice and doesn't admit it in the meeting? So these are the sorts of things that you can do in a unilateral way. But Susanna, let's turn to the course of dealings, because the course of dealings of a joint tenancy is a foundational element of the severance of joint tenancy. We've talked about agreeing to it. We can do it consensually. We can do it unilaterally. But more importantly, what happens is, what does that mean when we're talking about a course of dealings in terms of severing the joint tenancy?
Well, what that ultimately means is that there has to be some kind of a mutuality of intention to treat the tenancy as a tenancy in common. So both parties have to agree by their conduct that they're going to sever the joint tenancy. And as you say, many times, I see it in the family law context, when parties are in a position where they're going to negotiate some kind of a separation agreement, that conduct in dealing with a jointly held property and how that's going to ultimately be divided on a marriage breakdown is, in many cases, a course of conduct or a course of dealing that the courts can point to say, you know what, notwithstanding that the property is registered in joint ownership, there really was a severance of that interest, and therefore each of the parties has an undivided interest in the whole.
Right, let's just talk a little bit about cases, only because it's kind of fun. We've already mentioned one case, but there's a Williams and Hensman, Hensman decision. It's a 1985 decision where the court looked at where parties can't point to a deed or an agreement in writing that there is a severance of the joint tenancy. It looked at this whole question of what is course of dealing that is sufficient to initiate and affect the severance of the joint tenancy. And as Susanna says, we've got mutuality of intention is one. And our great fearless leader, Jordy R. Ayton, has written on this as well. There's a fantastic article in the Estates and Trusts and Pensions Journal that he wrote many years ago, highlighting some of the case law in this area. But the principle, of course, that he looked at is what are actions that are sufficient to initiate to come to the conclusion in the mind of a court for the parties to have had a common intention to treat the tenancy as a tenancy in common. And maybe, Susanna, you can tell us a little bit about what Jordy had to say on that point.
Yeah, and Jordy quite rightly pointed out that courts are reluctant to analyze strictly whether or not any of the four unities have been destroyed. And so that could explain why we don't talk about joint tenancies many times along those terms. What the courts prefer to do is to look at the circumstances themselves of each individual case and then determine whether there's this common intention to treat the property as a tenancy in common rather than as a joint ownership situation. And back to that Williams and Hensman decision that you mentioned, Ian, one joint tenant's intention, which is, in quotes, declared behind the back of the other, is not going to be enough to sever a joint tenancy. So that mutuality of an intention to do so is going to be very important.
All right, so to succeed in the determining if a joint tenancy has been severed by a course of conduct, the onus, of course, is on the party asserting the severance. They must prove that the joint tenancy was mutually intended to hold the property as tenants in common. And so we're aware of that proposition. So I guess what's kind of fun, Suzanne, is, and not to get too heavy in the case law today, but let's talk about a couple of other cases that really do drive the illustration points of what is sufficient to sever joint tenancy by conduct. And of course, the starting point always in this discussion is the decision of the Henson, Hansen estate. It's a 2012 decision of the Ontario Court of Appeal. And that decision is sort of our benchmark in this question. So maybe, Susanna, why don't we just talk a little bit about what that court considered in this context as to what was going to be sufficient to sever the joint tenancy?
Yeah, the joint tenancy in this case was in fact found to have been severed. And it was, again, a situation, as I mentioned earlier, where spouses were in a position of separating, and they were talking about how their assets would ultimately be distributed. So during the course of the discussions, the spouses closed their joint bank accounts. They opened separate accounts in each of their own names, and a new will was prepared by one of the spouses, pardon me, where he left his estate to his children. So the court found there that the intention was to divide their interests in the property and to hold that interest in common rather than jointly.
All right, so it's noteworthy, though, in this decision, it was not enough for Mr., in the case, the husband, to pass his share of the property to his daughters through his will. The court found that evidence, although it demonstrates some consideration of the issue, it wasn't sufficient. So it went on to say that joint tenancy itself, really, in Ontario anyway, joint tenant cannot be severed by this, in this decision, it cannot be severed by testamentary disposition alone. However, it's a provision in the will was found to be a pertinent piece of evidence that could be used to help discern whether or not there was a common intention to treat the severance as severed, the tenancy as severed. And so what you find in a lot of these cases is the conduct that's being explored is found in the lawyer's files. The exchange of letters can demonstrate the intention. The conduct of the parties outside of their behavior, like they did in Henson, what are they doing with their accounts? How are they treating the marriage at that point? So these are all important issues because, of course, we come back to that when we're dealing with our estate planning. Your client might come in and say, yeah, well, the marriage right now is a little spicy, but I want to update my will to make sure my grandchildren get sufficiently looked after. My wife and I have mirror wills, so I have the right. You're a brand new lawyer. I don't have any retainer issues. I want to change my will. They don't get into what is exactly going on in terms of a spicy marriage situation, and they find out that there has been a lot of conduct that has been engaged, and all of a sudden they're dealing with a property that they thought they owned, that they were going to receive by joint tenancy, and then their conduct has affected it.
And I think that, and I certainly, in my own practice, when I first came across the fact that, a testamentary disposition interest that was held jointly by partners, and this provision that you just mentioned, that in Ontario, a joint tenancy can't be severed in a will exclusively. We've got that Marley versus Salga decision of the Ontario Superior Court, 2019. I mean, that was a kind of a surprise to me initially because, it goes certainly to the intention. It goes to the parties' understanding of their interest in the property. Like if it were a house, for instance, and it was held jointly, and we know that it should go by right of survivorship, so we wouldn't be addressing it in our will. Well, the question arises, if you do put it in your will, and if you do say my interest in my house will go to so-and-so, that one would have thought would be sufficient to sever the joint tenancy. But the fact that it cannot be, and there has to be more than just that actual provision in the will to do so, is something that I certainly try to keep in mind because it wouldn't otherwise necessarily be so intuitive.
Well, that's great. And I think, no question always comes up in these cases is that from a litigation perspective, what do you need to do from an evidentiary standpoint to prove this case? Well, these cases are, as I say, often driven by the evidence of the professional's files. It does not, the severance of the course of dealings does not require sort of an explicit intention. So the court's got flexibility. So if there's not, I mean, it's sort of like undue influence. You don't, it's always done in secret. Well, there doesn't have to be an explicit intention to sever the joint tenancy. The mutual intention, though, and that's the key to the analysis, there has to be a mutual intention that is inferred by the course of dealings between the parties. You don't require evidence of an agreement per se, but the mutuality of the intention is very important from that perspective. Susanna, you mentioned the Marley Salga, SALGA decision, but maybe we can just talk a little bit about some of the principles that have come out of that case and others in that context.
Yeah, for sure. In that case, there was a husband and his second wife. They had a long-term marriage. They lived in the house, which was purchased by the husband, and title to the property was in the names of the two of them as joint tenants. Mr. Salga had 3 children from a previous marriage, and he had a will that he had prepared with the help of his lawyer, and it basically provided for the distribution of his personal property to go to his children, and the residue of the estate was to be split amongst the children and the spouse. The court in that case was looking at the evidence to determine whether or not it would be sufficient to prove that there was a severance of the joint tenancy, and whether or not, we could rely on this course of conduct in order to do so. And in deciding that there had been an actual severance, the court relied on 3 pieces of evidence. And the first was, of course, Mr. Salga's will, where he was dealing with the property that was owned jointly. There was a recording of a conversation between himself and his wife while he was in the hospital during the illness. And then there was this affidavit of a close friend of the husband who also was able to substantiate the conversation between them. And ultimately, the recording of the conversation was exactly that. The husband and wife had agreed that upon his death, there would be a division of the property, and that it would be split in half, and each would deal with their own bit. The affidavit of the close friend was supportive of that, and so the court was able to rely on those, 3-partite pieces of evidence to come to the conclusion that there was an intention to sever the tenancy.
Again, mutual intention is crucial. And so it was fun. And this is what you see in a lot of these cases, is that the court, if they're looking at the will, it's a fact for sure. And in that one case, though, the court, and this again weighs heavy on us as estate lawyers, the court looked at the terms of the will to see not just what intention they could glean from it, but what was the language used, and is it inconsistent in the context of the using the will in the question of the right of survivorship. And maybe you can talk a little bit about what the court looked at from the will standpoint, Susanna.
Yeah, it was interesting because in this case, it comes down to the language that's actually used. I'm just trying to find where that provision was, but basically it said that the wife would have the use, occupation, and enjoyment of his 1/2 interest in the home. So he clearly there was indicating that he thought he had only a 1/2 interest in the home. He allowed his wife to live there. And although the property was held jointly by the two of them, that was how the court was able to draw from that his intention, which was that it would be divided ultimately on his death.
And it's an important case only because, again, it was appealed and it was dismissed, but we're just looking for factors. So we started this off talking about the unity of tenancy, joint tenancy, and the importance of the 4-part aspect of the unity of joint tenancy and what needs to be there to create a joint tenancy. And so then the court starts to say, okay, we're going to respect the dignity of the joint tenancy. Now I want to talk about what is it that's going to take to split that up. And we talked about the mutuality of agreement. We can just outright agreement. You can obviously sever it unilaterally, and then finally this conduct. So really, from the standpoint of the court, when you see these cases and what we can glean from it, it seems to me is that the will is not unimportant, and the notes of you as a drafting lawyer may not be unimportant. In fact, they are both very important factors that the courts have consistently looked at when we're asked to consider whether or not the severance of the joint tenancy was there. So when I'm doing my intake, I'm very careful not to just gloss over the whole question of ownership. It's not just whether or not the client's understands the legal concept of joint tenancy and tenancy in common, whether the house is owned joint tenancy or not, but what, if any conduct would may be relevant to have affected the strength of that joint tenancy. There's other cases out there, and again, we're not here to get too heavy on the case law, but other cases that have looked at factors to consider the conduct being sufficient to sever joint tenancy. And maybe, Susanna, can you give some other, we don't have to get into the cases, but maybe give us some other illustrations of where the court's other factors that the court has looked at that has brought them to the conclusion that that's sufficient to mutually sever the joint tenancy.
Yeah, I guess certainly, again, in a marriage breakdown situation, if the parties have separated with no prospect of reconciliation, that's one of the factors that the court's going to look at. It's going to see whether or not the parties had joint accounts, which they subsequently closed, and if those joint accounts were previously held to pay for jointly held property, if there are actual divorce proceedings that are commenced following the separation, if both co-owners are making claims for equalization of net family property, if an appraisal, for instance, of the matrimonial home was obtained, that becomes a very important consideration, and if each party claimed a 1/2 interest in the matrimonial home on their financial statements. One of the things I found quite interesting in reviewing the cases is the fact that the discussions amongst counsel can become very important. And so if we're going to maintain the position that jointly owned property is going to pass by right of survivorship rather than be divided or severed and become a tenancy in common, we want to make sure that those instructions are clearly relayed to the lawyer so that the lawyer doesn't inadvertently make some comment that might be viewed as evidence of an intention to sever. And so that is certainly something that we want to keep in mind when we're seeking these instructions, when we're having these discussions, because we might inadvertently do something that wasn't necessarily something we had intended to do.
Yeah, and these are only factors. And I guess really what we find helpful when we think about this from an estate planning standpoint and the strength, really we're looking at how strong is joint tenancy? And it can be undermined by, as I've described, but it also can be undermined by this conduct. And what conduct can undermine the strength of joint tenancy, for which many of us are just relying on as the principle of law? The courts have looked at situations where the wife has sent a letter to the husband requesting that the house be sold to a third party, and this is the way it's going to split. And then that, proposals go back and forth. But you can tease this out like a law school question. I mean, one of the underlying concepts that they keep coming back to is mutuality. If it's something that is being done without sort of a mutual exchange, the course of conduct cases don't tend to allow for the severance of the joint tenancy. The courts talk about the mutuality of treating their interests as a tenants in common, as opposed to a unilateral treatment of it. If you want to unilaterally do it, you can register something on title and you can sever the joint tenancy. And the courts are very respectful of the fact that, both parties better be behaving in the same, rowing in the same direction, so to speak, to make sure that they're going to jump in with what can be a pretty draconian determination, and that the conduct has severed the joint tenancy itself. Susanna, before we wind up, do you have anything else you wanted to add on the topic?
I think the only thing I would add is the fact that when we're dealing with these kinds of situations and we're talking about rights of survivorship, sometimes the world just doesn't unfold the way we think it is. And so you be in a situation where perhaps a power of attorney comes into play and the attorney decides that they're going to sever a joint tenancy on behalf of the incapable person with the guarantee of at least having half of the interest in the property ultimately in the estate on that person's passing. But you're sort of guessing in terms of timing and the timing of death and the order of death. And we can't always plan on that because sometimes things just don't work out the way we do. And so someone who was expected to outlast the other individual could predecease, and there are complications that could arise as a result of that. So just another one of those things that we want to keep in mind as part of the planning process and ultimately on the administration side of things when we're stepping into the shoes of someone who is no longer themselves capable of severing something independently, but would be doing it through a fiduciary, and what those repercussions might ultimately look like at the end of the day is something we want to keep in mind.
Well, that's great. Well, I think I've got close enough to my real estate understanding that I can. Now we're getting dangerously close to being tax lawyers and real estate lawyers, so we don't want to get near that. So I hope this has been helpful. It gives us some context for what is a very standard principle of law that we use every day in our estate planning. So look forward to seeing everyone next week, and have a great weekend. Thanks very much.